They signed up for it. The taxes were going to be like in excess of like $100,000. And so, of course, the son is upset. And so he sends the paperwork that they waived it. And it's like, yeah, they only wanted this. It's like, wait, they chose not to have this language? Yeah. But it's going to be more than $100,000 in state taxes. What would it have cost to have the language? $50. Hi, Jeff Marsace, the Plain English Attorney, and welcome to the video. And today we are going to talk about never would I ever estate planning, or never would this ever happen estate planning pieces. And it really goes to just talking about how we should be thinking about and approaching estate planning so that it's not so current and specific that you're not allowing for changes to happen in life. And I see this all the time, and I've got 7 big examples. The 7 big examples, they happen a lot, particularly when people don't check out the materials ahead of time. And I've got my free course, the freetrustcourse.com, which talks about estate planning and how to approach it, and looking at here's what probate is and what it does versus a revocable living trust. And it gives that kind of background, but it also does talk an awful lot about recommendations on how to approach and think things. So the very first one I hear all the time, usually it's guardianship, but sometimes it's about executors and trustees and powers of attorney. It's, oh, I want my brother and sister-in-law to get my kids. If anything happens to me, I want them to be guardians. Whoa, wait a minute. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. Is it your brother and sister-in-law? Or is it your brother that you want to be guardians? Because you should just assume right off the bat that there's a 50% chance that they're going to be divorced, just because that's what the statistics are. And I hear it all the time. Oh, that's never going to happen. No, they're going to be together forever. Never is anything going to happen. And then you find out, oh, yeah, it did. One time, many years back, before I started telling this story, it was 2 women. I believe they were both divorced, or one of them could have been widowed. And they were talking about who would actually raise their kids, if anything. Oh, I want my parents. I said, well, look, I know it's your parents, but there is a 50% divorce rate that's out there, so you really have to think about this. And what I suggest, because we're typically looking for 3 people in succession, okay, pick mom or dad, and then add 2 more. So it's okay to have 4, but you don't want to have less than 3. So let's kind of name them. Oh, no, you put them down as equally getting guardianship. Nothing's ever going to happen. Within a 6-month period of both of these clients coming in, naming the parents as co-guardians, they forced me to do it against my judgment and advice. One of them, yeah, my parents are getting divorced. And the other is, well, they're separated. I don't think they're getting back together. And so we had to make a change. And so when I tell that story, I said, please, 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 name them in order. Don't make me curse your parents' marriage and have them break up because you insisted on making them co-guardians. So name one person at a time. Now, when you're looking at this, you also want to really think, okay, if I'm going to name my brother first and my sister-in-law, you have to think, okay, what if they are divorced? More than you would think, they do love, trust, and believe that that sister-in-law that got divorced from their brother, if they ended up as guardian, they would still do the right thing and be a very good parent. Okay, that's fine, but you should always assume that they're going to get divorced. So don't ever oh, they're never going to get divorced. It happens, and it even happens to parents, and we don't like it, but look, that's the reality. So that's the first one. What is the second? Oh, never would this ever happen, or never would I ever. The second one is, oh, I would never sell or get rid of this particular asset, or that, so I've got this house. I love this house. I am never, ever, ever going to sell it. So the way I want to divide my estate up is the house is about half of my wealth. I want the house to go to this child, and the other child gets everything else. Well, wait a minute. What if you're not in this house? What's going to happen? Oh, no, that's never going to happen. I'm always going to... Look, it happens all the time. Situations change. Now, the one that's really coming to mind is I had parents. They had one daughter. She was special needs. She lived in the house with them. And, oh, she's never, ever, ever going to leave the house. That's going to be her house until the day she dies. And they were actually making me strip out just general kind of safety language, what if language in the trust, which is a very common thing. When we do trust, we've got a very thick trust, and it's got a lot of different contingencies, and it's, oh, this is never going to happen. Well, it's there in case it does. And so for this, they were stripping out the trustee's right to make a mortgage or do a loan with real estate owned by the trust. And it's like, well, we paid off the house and we're never gonna have another house and blah blah blah, and they made me take it out. So thinking ahead, I crossed it out, wrote in the notes against advice, clients want this out. It was only about 3 years later, probably not even, that their daughter ended up with this opportunity to move into a house, kind of a group home that the parents were setting up. So they were collectively, I think it was 7 of them, they were going to buy this house, and they were going to collectively hire a person who was going to be living to help them become more independent, actually have group teaching sessions on certain things within the house. It was this whole great thing, and now she's going to be able to socialize more with people her own age and blah blah blah. And they wanted to own their 1/7 inside the trust. And when they went to the bank and they were like, oh, this your attorney screwed up this trust, blah, blah. He needs to have this language. And so what did they do? They came back yelling and screaming that I screwed up their trust. Okay, send me the language. And I already pulled the file out and I already knew what was going to happen. They sent me the language, and then I sat down with them and I was like, okay, here's this language. And then I pulled out my notes with the writing on it that they made me take it out. And I said, I want you to read this paragraph and tell me if it doesn't look a lot like that. And they were just like dumbfounded. And I said, all right, here's what it's going to cost per hour for me to fix it, and I will fix it. But I don't want to hear another thing about how it's my fault that this was taken out. So, and again, it was that whole mentality, never is anything going to happen. This particular asset, the house, well, they still owned it, but they could have sold it and got another house. And what if that house had a mortgage and the daughter ended up in the house and the trustee could renegotiate the mortgage for a much lower rate? No, they would have taken that out. So you always have to think far ahead and leave open these possibilities. So don't ever think that, oh, I'm never going to not own this particular asset. Where I sometimes see this, and okay, that makes sense, it's not the expensive stuff, it's the sentimental items. So things like an antique writing desk that may not have a huge dollar value, but it's sentimental because it was from my great Aunt Tilly and whatever, and I want this to go here. We typically have a memorandum of personal possessions and where they go that's attached to the trust, so things like that can be updated and changed, but you don't use that with the expensive stuff. So that's the second big one, is assuming, okay, I'm never going to have this asset or not have this asset. It's always going to be there. And therefore, I'm going to specifically say, here's what happens. And we're going to structure the document and structure the allocations around the fact that I am so sure I'm always going to have this. What's the third big thing? Failing to look at contingencies because, oh, they're always going to outlive me. So it's, okay, I'm leaving everything to my, equally to my kids. Well, what if one of them dies? Oh, that's not going to happen. Well, look, we don't know what life's got. No, it's never going to happen. But what if just, no, don't even bother with it. Let's move on. Okay. I don't know how many of you remember, because I did videos and other materials on this. In fact, I did a whole a workshop piece around this. Anna Nicole Smith. She was a Playboy model and then a kind of reality TV star, and she had a lot of money. She married this Texas multimillionaire, probably billionaire, a Texas billionaire who was like in his 90s, and she inherited some of the money, and there's all this court stuff, but she ended up with her own reality TV show. She had a son, not by this 90-year-old person. And then afterwards, she ended up having a daughter. But between the son and the daughter, she did her will. Okay, she wasn't going to do a trust, even with all that money. Fine, whatever. At least she did a will. And it was a pretty expensive attorney in California on Rodeo Drive. So, okay, I leave everything to my son. And then I'm not leaving anything to any children who come after me. And the question is, well, what if something happens to your son before you do? I can just hear it. Oh, what are you talking about? Why is it my son? My son's not going to die before I do. Why are you saying that? If you've ever seen the reality TV show, you probably had echoes of that going through your head. Well, look, the son ended up dying of a drug overdose. She had this young daughter. And so it became a huge fight. And so by failing to look at this contingency of what if somebody passes on before you do, and at least going a couple of layers deep, it got thrown into chaos because she basically disinherited any future kids, but left absolutely no guidance for where the estate would go if her son didn't die. So what ended up happening is the judge ruled, okay, there are no beneficiaries, and therefore we go to intestacy, and her intestate heir is that daughter. And so she ended up getting the estate because the alternative would be, I guess it would have been going to aunts or uncles or cousins or something, you know, nieces and nephews, rather than the daughter. And so because there wasn't any beneficiaries left, they just went to intestacy and they kind of ignored the whole will. Okay, so that was just assuming someone's not, as a beneficiary, isn't going to die before you do. Okay, what's the fourth big thing that we're talking about here that never would this ever happen? It's thinking that I'm never going to have another child somewhere in that mix. So if you're going, okay, well, I want everything to go to my two kids. Well, are you ever going to have, oh, we're not going to have a third. Well, wait, it's possible that you, no, it's never going to happen, never going to happen. Well, okay, there's adoption. No, not going to happen. Don't even bother. Well, okay. This is a very standard thing if you're leaving everything to your children equally. You don't have to specifically exclude any future children. It's not really going to do much other than add a few words to paper on the trust itself or in the will itself, saying I'm leaving everything equally to these to the children who currently are, and making the provisions for them and listing it in the trust. Here's how this goes for this particular share. But just add in, what if there is? This is particularly true. There are, quote, oops babies. There is, well, okay, my sister and brother-in-law died and I ended up being the guardian. We want to adopt the kids and include them in the estate. Look, it's already taken care of. If they're officially adopted in, then they're adopted in and it's done. So that's a fourth big one is, yeah, okay, they could be included. It also kind of goes along with naming guardians and things like that. So you never know what life's going to throw at you. You may end up being a guardian for a child, and you may want to end up including them. One of the first duties as a guardian, this sometimes happens more than you would think, that grandparents end up raising their grandchild. They kind of go along with, oh gosh, we got to get back into thinking about PTA meetings and after school sports and all this other stuff. We just got to get back in the groove of that. And they kind of push to the side that, well, wait a minute, you're guardians now. Part of your planning should be who's going to take over guardianship if anything happens to you. So don't ever say never. As people get older, sometimes it's a lot less likely, but don't ever think it's never going to happen, and realize, especially if there's guardianship issues, wait a minute, we got to go talk to the attorney and make sure we're incorporating this into the plans we have. All right, so what is the fifth big thing? Oh, I'm never going to have a taxable estate. Oh gosh, you just never know. Because right now, it's 2023, it's $12.96 million is that threshold, and after that it's taxed, but that's federal. Some states have a lower limit or threshold, and thinking, oh, we're never going to have a taxable estate, so let's throw out all of that stuff. It's never going to happen. We're not going to need any of this tax language. Oh, whoa, wait a minute. Money grows over time. If the estate tax limits don't grow correspondingly over time to keep up with that, then it could be an issue. And right now, at the end of 2025, that 12.96 million or whatever it's indexed to go up to gets cut in half. And that doesn't mean that the state can't come in and also put in its state level estate tax. So that tax language should be incorporated into your trust right off the bat, and leave it there. Don't ever say it's never going to happen. And this is, if you've ever seen or read the book, The Living Trust by Henry W. Apps III. It's a good book if you want to really get into it. So hang on a second. I was actually referencing this yesterday. It's right here. The Living Trust, very, very thick book. It's a lot thicker than the materials I have in Estate Planning Basics, which is part of that. We've got the digital and audio versions on freetrustcourse.com, so go ahead and get access to that. But he told this story many years ago about when his company was doing trust documents for attorneys, and they had the standard language, and they could get a trust, an AB trust, or an ABC trust, and it's just the tax language, and there was a price differential there, and it really wasn't much. This couple, oh, we're never going to have a taxable estate. Never going to happen. Oh, no, it's not going to happen. No, we're not going to do this. All right, so they signed up, and part of the language is, okay, if we're getting this married A trust without the tax language, you realize that if you have a taxable estate, you're not doubled up. Well, okay, the couple ended up dying. They ended up doing a lot better financially than they ever thought they would. And here you go. Suddenly, they end up with a taxable estate, and the son's like, I'm going to sue you. How dare you? You don't even have a credit shelter trust. And okay, so let me look through my files. Okay, look, they signed up for it. The taxes were going to be like in excess of like $100,000. And so, of course, the son is upset. And so he sends the paperwork that they waived it, and it's like, yeah, they only wanted this. It's like, wait, they chose not to have this language? Yeah. But it's going to be more than $100,000 in estate taxes. What would it have cost to have the language? $50. So they lost more than $100,000 in estate taxes because they didn't have this general language they weren't willing to pay $50 for. Thankfully, Henry and that company, the company's still around. It's the Estate Planning Source. They're not charging different amounts for the documentation to the attorneys, whether it's an A, an AB, or an ABC trust. So all that tax language is going to be in there without any additional cost, just because of situations like that as a standard. So they don't want this $50 to end up with $100,000 as a price differential now. So it's out there, that attitude, oh, we're never going to have a taxable estate. Look, money grows, and the estate tax laws are completely up to the whims of the legislatures. So, all right, so what is the sixth big thing? Oh, I'm never going to outlive my trustee. I'm never going to outlive these two trustees. And I really always push to have at least 3 people named in succession as trustees, powers of attorney, and those types of financial agents, as well as healthcare, maybe a different set of people. But okay, so we want those 3 people. Oh, and this happened, and it was someone in the industry. I don't want to give out too much, but they should have known better. Oh, I'm naming my brother as the trustee. And this was an irrevocable trust. Well, okay, who would be second? My brother's going to be fine. He's going to way outlive me. He's very, very healthy. Well, look, just in case. No, I'm not going to do it. Well, look, we need two more. No, just name my brother. At least put in a company. Okay. Again, this was an irrevocable trust. So we named a trust company that was second in line because he didn't want to even bother thinking about the fact that his brother may pass on before he does. All right, so what ended up happening? The brother passes on. And now it's an irrevocable trust. Okay, this company ends up being manager of and the trustee over the trust assets. And he had a change of heart. I don't like them anymore. Okay, so what we had to do, and this happens with the irrevocable trust sometimes, we set up a second version, have the trustee transfer the assets so that we can have a different trustee with very similar terms without breaking whatever the purpose was for the irrevocable trust. But it was a huge expense because you just didn't name that second and third. Don't ever assume that people aren't going to pass on before you do. That is one of life's biggest curveballs. It happens all the time. So assuming that an agent's going to outlive you, don't ever bank on that when you're doing estate planning. And then the last big thing. Oh, my beneficiaries are always going to be healthy. There's never going to be a need to have this language about special needs provisions. And what I hate is when I hear attorneys not put this stuff in standard in their trust. And so they'll do a trust. Well, they don't have any special needs beneficiaries, so we don't need to have any of the language and the protective language to make sure they don't lose their Medicaid and other disability benefits or any of that stuff. It's not needed. So, and some of them even make you think, well, you're just charging them extra money for that. No, look, it just should be standard language in the trust that if a beneficiary ends up being on a program that would get them disqualified if they got that inheritance, then it automatically triggers the language that protects the money as an inheritance so that the trustee can work within whatever the rules are to get them what they need without actually having to give them money directly, which would disqualify them from their benefits. So, and then again, this happens all the time. It was even part of the book that I put together, The Simple Guide to Special Needs Estate Planning. It's still out on Amazon. It's due for an update, and I probably will in the next year or two. But it really went through that. Here are the rules. Here's what it specifically says. And so, oh, my kid's never going to have this issue. They left them directly money. And now they're getting kicked off of disability and Medicaid. They had to spend, it wasn't a huge estate, but they had to spend like $60,000 immediately, or they're going to lose their Medicaid and disability. And that would have been about, let's see, about 10 years ago, it was about $2,700 a month. And they have to spend all that money down. And I remember sitting there with the beneficiary and their social worker, and it's like, well, they could really just use this money to be set aside for. Well, you can't. They didn't do the planning the right way. It just said I leave everything to my child, and it goes outright, and that's it. End of story. I mean, there could have been some more complex things that they could do, go to court, get something set up. That wasn't what I did, but look, it would have been so much easier if it was just a standard part of the documentation. And don't ever think, oh, it should just get thrown out because it's not relevant. It very well could be relevant. All right, so those are the 7 never would this ever happen things in estate planning that we come across all the time. So please help us out by subscribing to the channel, like the video, go ahead and share. It really helps get the information out there. So as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.